Okay, so I thought it would be kind of interesting to discuss probate today. And probate really is the way that a will becomes valid and beneficiaries get assets. Very often, when families pass away, it's very confusing, a very difficult time. And one of the first questions is, well, what do I do now that my family member has passed away? And so understanding probate and understanding sort of the next steps that happen, I think, is very important for people to sort of calm them down and bring the temperature down in the household. And of course, I tell everyone, the minute a family member dies, you got to deal with those emotions and you got to deal with that situation at hand. The legal financial stuff can wait a couple of days, as long as you're, getting the death certificates, we can handle everything else. Now, why is it probate? What is probate and how can you avoid it, or can you avoid it? Is because, and very often when someone passes away, there's a situation where, you have to find money very quickly in order to bury the person or the next steps. So there are ways to avoid probate so that you don't have to worry about that as well. So first and foremost, what is a will? Uh, when I speak with clients, I usually tell them, there are documents that deal with when you're alive and legal documents when you pass away. So the minute you pass away, your last will and testament is the operative document. It's a legal document which appoints somebody to handle your affairs after you pass away, called an executor or executrix if you're female, and oversees the distribution of the assets to the beneficiary. So if your parents pass away or somebody that pass away and leaves something to you, the will dictate that what happens. Instead states the testator's wishes. So the testator is the person who passed away. So in your will, you get to say exactly what you want to leave, and to whom, and what amounts, and when. So it's a very powerful document, and sort of you get to dictate things. Is only enforceable after you pass away. A lot of times people come to me and say, look, my will says this. My will says my son or my daughter is in charge, and so they're in charge now. No, it's only legally enforceable after you pass away. And wills require formalities to be valid. A lot of times I'll get, napkins or things like that. And actually a will is quite complicated. It has to be signed at the end in front of two witnesses and notarized, and has to have certain formalities in order to be valid. So, often people, say, what is probate? What is it that probate does? So it's a court process, and it's how your will gets validated. So the court oversees all of the steps in order for you to get your assets or, personal property. And it takes time and it takes money. Court processes are expensive. You're in court. Something could be disputed. People often say, how much is this going to cost? And it just depends. If people are getting along, it can go pretty smoothly. But if people don't get along, it could take years. The state of Connecticut requires that you complete probate within a year. I've never seen them enforce that. It certainly can be done if everything sort of aligns, but sometimes it takes longer if there's disputes. So what actually goes through the court process called probate? So only assets that are solely owned by you when you pass away. So that's one clue of how to avoid probate. So you won't have to go through the process if you hold assets jointly. So if you and your spouse or you and your kids have a joint bank account, that will never go through your will. So all day long, you could say in your will, I want this account to go to X. And if it's held jointly, it's going to go to that person that you hold that account jointly with. Beneficiary status, like life insurance policies. If you say, I leave my life insurance policy to Chris or John or Susie, it's going to go there immediately after you pass away. It's never going to hit your will. It's just going to go to that person. And that becomes difficult when you get divorced or when you no longer speak to people. So you have to change your beneficiary statuses when your situation changes. And assets distributed through trusts. So trusts have beneficiaries. So anything that gets distributed through a trust will go directly to that person that the trust dictates. So those are ways to avoid the time and the court fees, et cetera. And this is especially helpful. I'm sure Jeff could tell you when you're dealing with property. And if you have a house, and sometimes in the middle of a house being sold, someone will pass away. If you have to go through the process of probate, it's going to take a while before you can sell that house, and very often you lose the buyer. If you avoid probate by either having the house held jointly or through a trust, then you could sell that house or continue to sell that house immediately. So we talked about probate and what happens when you die with a will. So what happens if I don't have a will and I pass away? Well, it's a little bit more complicated. And I often tell people you have to think of probate in two different sections. One is with a will and one is without a will. So when you pass away without a will, the process instead of probate is called administration. It's very similar to probate, but in this case, you didn't have a will to say who you wanted to leave things to and who you want to be in charge. So the state sort of dictates what happens. And you could say it's called intestacy. And you could see in this slide, which of course, if anybody wants the slide, happy to send it to you. Just send me an email. If you have children but no spouse, the children will inherit everything. A spouse but no descendants, spouse inherits everything. But very interesting when you have a spouse and children and you don't have a will. So the spouse inherits the first $100,000 of the property and half of the remaining. And the descendants, very often the children, inherit the rest. So if you don't have a will and you have minor children or even adult children and you're married and you pass away, then all of a sudden your spouse is going to share ownership of your property, more than likely a house over $100,000 with your children. And that might not necessarily be the thing that you would like to have happen. So that's why it's very important to have a will. And also, as far as administration, it can take a little longer. And also you have to post a bond very often, which is insurance. So it's a little bit more complicated without a will. And you also can't say who you want to get things and how you want them to get them. So why would you want to avoid probate? Well, the time. So, very often at minimum, it takes a year to go through probate and get your assets. The cost, you have probate fees, which are very high right now. Everything you do in the courts, very expensive. And during the pandemic in the beginning, the courts were even closed. So we had a hard time, dealing with distribution of assets. And, the fees, the legal fees, are, not terrible, but, they're not cheap either. So how could you avoid probate? So like I said, hold assets jointly, have beneficiary on accounts, and utilize trusts. However, you got to realize too that sometimes you don't want to hold your assets jointly with somebody because you might not want them to inherit solely when you pass away. You might have 4 kids, but if you have one person on that account, that one kid is going to get all the money. The preferred way really is to utilize a trust. And the reason why the preferred way is to utilize a trust is because, once again, like a will, a trust, you can dictate what happens. It's not just that one person you hold that account with when you pass away. So a trust avoids probate for the most part. And also you have you're able to dictate what happens. A trust also is operative while you're alive. If you think of a legal container, which is why I put that container on there, you're just putting assets in that trust, especially a revocable trust, which you maintain total control over your life when you pass away, and it'll distribute as you stayed in that trust. So the advantage is it avoids probate because whatever beneficiaries you have there, the assets will go. So it avoids the time and costs and fees. It organizes all your assets in one place, so your house and all of your other assets are going to be contained within that trust. And let's say you became incapacitated or sick during your lifetime. The trust is operative during your lifetime as well, so you can start using your trust, and then your next trustee down, one of your kids, your spouse, whomever, can help you manage assets and very often stay at home, which is important to people like Daniel because it helps people stay at home as opposed to going to a facility. Is private, diminishes court contests. So the trust distributes immediately after you pass away. So there's really no time for people to start contesting the trust. And very often they'll contest a trust that has no money left in it. So, good luck with that. It's easy to amend. It's not like a will. When you change your beneficiary statuses in your will, you often do a new will to avoid contests. With a trust, very easy to amend. It's a pen stroke, and you amend that section of the trust. Very often people ask about maintenance fees with the trust, which I'm always confused about because there aren't any. It's your trust and there's no monthly, yearly, or whatever fees. If the trustee is someone other than yourself, they can get what's called commissions. So they get paid to be trustees. So if you become incapacitated or pass away, there are commissions that are paid to the person for doing that job. that there's no maintenance fees. The only disadvantages to a trust really are the initial costs. It costs a little bit more to set up, and you have to actually do something with the assets in a trust. You have to actually put them in the trust. So instead of the Mike LaMagna account, it's the Mike LaMagna trust account. So you have to actually go to the bank and transfer over the assets into the trust. It's not a big deal, but it is something that you have to actually do. And just real quick, the will versus trust. The will is operative at death, whereas the trust is operative immediately during life and after you pass away. Will requires probate, the trust doesn't. When you amend a will, you do a codicil, or you actually have to do a new will. You can amend a trust freely. Will requires court approval, and it's actually, the probate process is a public process, so you can look at what other people are getting or doing. Trust is very private. The trust is more immediate and diminishes estate contests, and they're very flexible, as opposed to a will is not flexible. Any questions?
I have a question, Mindy.
Hey, Mindy.
Hey, so I know that I was watching Susie Orman, and she said, trust, trust, trust. Everybody should have a trust. So if you have the trust, do you have to have the will as well?
Okay, so three things. One is, I like Susie Orman. Number two, I'm not necessarily sure that everybody needs a trust. If you have somebody who, walks in the door, has 2 bank accounts, or held jointly with their kids, they probably don't need a trust. So it depends on the individual situation. Many people do, but not everybody does. The third question is, so if I have this trust and I have all the beneficiaries, why do I need a will? So you need a will for the following reasons. Number one, sometimes there's a court proceeding that happens, like a medical malpractice or et cetera, that you need an executor to be appointed later on. Or there's assets that you forget to put into the trust during your lifetime. So something has to happen with those assets. So very often you have what's called a pour over will, P-O-U-R. So the will pours into the trust after you pass away and distributes to the beneficiaries. So very often you do a will. It's a very, very quick will. It just says whatever I have in outside of my trust goes into my trust after I pass away. And very often you don't use it, but there are times where you forget to put an asset in, or there's a tax return that came that you just need, that you need a quick process called a small state administration. So yeah, you still should have a will, but very often it's never used with a trust.
Mike, can I ask a quick question?
Sure.
So with a will and a trust, there's directives to what the individual wants. And you said if there's disputes, it creates a lot more time. Why are there disputes if the directives have been, mentioned or directed?
Heck if I know.
Okay.
So siblings generally don't get along. And the reason why I spend most of my time in court in Nassau County is because people, even though the directives are there, very often the siblings or the family members will say, I took care of mom told me that I should have more of a share, so on and so forth. Very often we use interim or no contest clauses in the wills that says, if you contest mental capacity for me to do this will, then you're going to lose inheritance. So, very often it's, they claim that somebody's under duress when they were signing, is one of the big claims, mental incapacity, etc. It's an uphill battle for the people that are contesting. And there are ways to build in these documents disincentives for people to dispute them, which is helpful. So, but even so, there's definitely a portion of my practice, probably 20 to 25%, that is in court, with people disputing wills and trusts.
Michael, thank you so much for your presentation. I highly recommend everyone have a one-on-one. I'm sure that we can go on and ask you questions. Let's break now.